Hi everyone, welcome from Law with Dunk the Law Guy, and today is day 63 of the Case Today series journey covering cases across criminal law, tort law, contract law and the English legal system. If you ever have a case you want me to cover, pop it in the comments section and I'll get round to it. Today I'll be the almighty Dunk, or at least I'll try to be, God of Law and Thunder. As embarrassing as this is, I really do need the mask, and I will be holding my hammer too, Mjolnir. Please be aware that the case recordings are available on TikTok, YouTube, Instagram, Facebook, Twitter and on Spotify too. Simply search Law with Dunk the Law Guy or at Dunk the Law Guy. And to law teachers and students who may prefer an electronic copy instead to read from, so far I've uploaded both PDF and Word document versions of actus reus, causation and mens rea handouts to my shop on test.com, which I hope will help you should you want these. The shop is called the Law Guy _Law Library Shop. These resources are also available on Kindle. Once launched, I'll be uploading these to my website too, which will be called thelawguy.co.uk. Today, I'd like to cover the case of Collins v Wilcock, 1984, and touch upon its relevance to the criminal offence of battery. Apparently, the actus reus of battery was defined in the joint appeal cases of R.V. Island and R.V. Burstow, 1997, as the application of unlawful force, which can be either direct or indirect, and the mens rea apparently established or at least acknowledged in a case called R.V. Venner, 1976, as the defendant either possessing an intention, I always stress direct intent, so where the defendant possesses a main aim, desire or purpose to cause a particular result, as seen in R.V. Mohan, 1976, or recklessness, so subjective recklessness, where the defendant appreciates the risk and goes on to take it, as seen in R.V. Cunningham, 1957, to apply unlawful force upon the victim. In Collins v Wilcock, 1984, the issue for the court was to consider whether a woman's conviction for assaulting a police officer was lawful or not. In this case, a police officer was attempting to question a woman suspected of being a prostitute. As the woman walked away, the police officer grabbed her arm. Under the Street Offences Act of 1959, the police officer had no power to physically grab the woman or to detain or restrain her in any way. During a struggle between the woman and the police officer, the woman scratched the police officer and she was charged with assaulting a police officer in the execution of his duty. I'm not laughing at the case facts, I've just got a nervous laugh because of this ridiculous costume. Anyway, I'll move on. The issue before the court therefore became whether the woman could be guilty of this offence when you consider the police officer had no permission to grab her in the first place. The court held that the police officer had no power to arrest the woman and was therefore acting outside his authority. Furthermore, it was decided that the police officer's actions, i.e. the unlawful arrest of the woman via the grabbing and subsequent struggle, amounted to the criminal offence of battery, specifically direct force being applied, and the woman was entitled to resist as a form of self-defence. As a result, she was found not guilty and her conviction was quashed. The court also clarified when a battery could take place and stated touching another with hostile intent or any intentional touching outside the scope of acceptability would amount to a battery. Lord Justice Goff LJ provided that any touching of another person, however slight, may amount to a battery, but went on to further clarify in his judgment when a battery wouldn't exist, such as in situations where there is implied consent to force, e.g. where one touches or accidentally knocks another in a crowded place, or the force used during handshakes or tapping someone to gain their attention, provided the force used is reasonable in the circumstances. Here this case was different and the actus reus of battery was proven because the woman didn't consent to the grabbing of her arm by the police officer, and so the application of force here was not only direct, i.e. the grabbing, but it was also unlawful as she didn't consent. And that's it for today. Thank you from Law with Dunk, the Law Guy.